Good morning, everyone. Thank you for joining our workshop, Advocacy at the Municipal Level, Understanding Municipal Land Use Law. My name is Elliott Ruga. I'm the Policy and Communications Director at the New Jersey Highlands Coalition. I will introduce the concept of the Municipal Land Use Law, how this chapter of New Jersey law came into being, and the purposes it serves. I will then hand off to Chris Miller, a land use attorney and the executive director of the Eastern Environmental Law Center, to do a deeper dive into the law itself. And finally, Alex Ambrose, policy associate at ANJEC, will take us through a case study about a recent successful grassroots effort that opposed a project that was in conflict with a community's values. A good part of what we do at the New Jersey Highlands Coalition is to fight inappropriate development projects and to guide grassroots efforts when we get a panic call from someone first finding out about the 500-unit residential development proposed for the woodlot down the street where, as a kid, they had tree houses and forts, picked wild grapes, learned to make sumac tea, and knew of a secret place to gather chanterelle mushrooms. More often than not, these very upset residents are daunted by the machinations at play, having never attended a municipal planning board meeting. They see the cadre of attorneys and experts in business suits carrying sheaths of documents and charts, making presentations to the planning board, members of their community who they've never seen before, supposedly representing their interests, speaking in unfamiliar language, discussing such arcane concepts as C and D variances, floor area ratios, presumptive densities, and the dreaded builder's remedy. And we have seen these energized neighbors who from scratch soon become seasoned experts in analyzing site plans, questioning stormwater experts, successfully challenging what was purported to be a wetlands transition area. It doesn't happen with frequency, but it happens enough that the development fails to get approved. And to ensure that that woodlot forest with tree houses, forts, and wild forage is never converted into yet another gated condo, and the land is purchased for conservation purposes and is protected forever as open space. When this happens, it is usually the result of many, many hours of many patient, committed volunteers who, aside from spending their evenings in municipal meetings, also conduct fundraising events, write letters to editors, hold rallies, attend strategy sessions, and never give up. The deck is certainly stacked against the mere citizen. The well-heeled developer has the legal team and the impressively experienced expert witnesses. The developer knows how the system operates. The municipality, if it isn't outright in support of the developer because of its misguided belief that the taxes collected from the 500 residential units will actually be greater than the increased cost in municipal services, will typically restrain from a heroic defense of its master plan, because such a defense will likely result in litigation that makes a hack municipal attorney shiver and result in legal fees that causes your town's business administrator to cry. This is where understanding the municipal land use law is important, because it is the law that mediates between the rights of a private property owner to develop their land and the obligation of a municipality to ensure that those rights do not trump the rest of the community's right to quiet enjoyment of where they call home. If you are in the position that your town is either in favor of that awful character-changing development, or it doesn't have the will to defend against it, an understanding of the law will allow you to wield a very powerful weapon, the weapon of delay, by ensuring that all of your rights are honored, to be properly notified of all meetings, to question and to be heard, to fully participate in the public process, and to insist that the process is carried out to the letter of the law with full transparency will introduce delay in the approval process. And if you can introduce enough delay, it only adds additional legal and consulting costs for the developer, and it would not be the first time that a developer sees they are throwing good money at a bad project and give up. And if you are prepared enough to have a conservation organization waiting in the wings to offer to purchase the land for preservation purposes, you would be a very smart cookie. So here are three simple words worth remembering: delay, delay, and delay. I feel it is important to point out that the New Jersey Highlands Coalition does not oppose all development. People need places to live, and we strongly support calls for affordable housing, and that municipalities have acted poorly in accommodating this need, whether out of laziness or in deliberate attempts to exclude people of color or low-income people. But we also strongly believe that New Jersey should not be sacrificing the last of its natural landscapes for new housing, that every tree cut down for this purpose comes at our peril. Instead, we must focus on redeveloping our cities to make them vital, vibrant, and affordable. We've heard that New Jersey is a home rule state, sort of, with its 565 municipalities and 611 school districts. It might appear that way, but home rule is not a constitutional right in New Jersey. Land use power in New Jersey resides with the state legislature. The New Jersey Constitution states the legislature may enact general laws under which municipalities, other than counties, may adopt zoning ordinances. Such laws shall be subject to repeal or alteration by the legislature. So what the state gives, it may also take back. In an extraordinary intervention by the state, with the passage of the Highlands Act in 2004, the state effectively took local control away from 52 municipalities that had land in the preservation area. As the Highlands Act explains to us in its preamble, despite the best intentions of municipalities, counties, the state, and other interests, they were ineffective in controlling the rate that sprawl development was destroying the forested lands that were the major sources of New Jersey's clean water supply, which the state saw was at critical risk. Despite lawsuits and claims that the Highlands Act was unconstitutional, the Highlands Act was held up in court in its numerous challenges. The United States Supreme Court was petitioned to hear an appeal, but the petition failed. In 1975, the legislature delegated certain land use powers to municipalities, which became known as Municipal Land Use Law, which provided for municipal zoning based on a municipal master plan. It provided for the formation of a planning board, which drafted a municipal master plan and made recommendations to the governing body to adopt zoning ordinances and other land use ordinances that were consistent with the master plan. It enabled a process that variances to strict application of those ordinances could be applied for by satisfying certain criteria through an application to the Zoning Board of Adjustment. In more recent years, under certain circumstances, the functions of the Planning Board and Board of Adjustment could be combined to form a land use board. It also enabled municipalities to form other volunteer boards, such as environmental and historic preservation commissions, to review projects that affected identified natural and historical resources, with the aim to protect these resources because of their value to the community's health, safety, and in preserving community character. Out of this, a new legal specialty was then born, the land use attorney. And I'm about to introduce you to one of the best. Chris Miller is a seasoned land use attorney with 12 years of practice at a preeminent environmental law firm, Mariziti and Falcon, where he was a partner. Today, Chris is the executive director of the Eastern Environmental Law Center, which provides legal services at a fraction of a private firm's cost to help citizens and environmental organizations to defend against inappropriate development projects. So Chris, it's your turn.
All right. Thanks a lot, Elliott, and thanks for that great introduction. I'm really excited to be in this session with you and with Alex, and excited to see that we have a good number of folks joining us this morning. Great. Well, thanks everybody. There's a lot to talk about with the municipal land use law. There's procedural aspects that differ in different standards of review for every different type of development. And obviously we can't cover them all right now. So what I'm going to try to do is just sort of give an overview of the process. How can concerned citizens participate in this process? What are the various entry points where you can have your voices heard? And along the way, I'm going to point out some of the places where a land use board can get tripped up in a way that can totally derail a proposed development from a legal standpoint. And when we think about proposed development, unsustainable development, there's the federal level, there's, depending on the size and scope of the project, the state level, DEP permits can be required, but those do not obviate the need for projects to get local land use approval. There are instances where preemption come into play, and the municipal review is not in every case coextensive with state and federal review, but in virtually all cases, proposed development is going to go through the municipal land use review process under the municipal land use law. So it's very important if you want to mount, a full-scale opposition or an effective opposition to proposed development, to get engaged in the local land use process. And so I'm going to sort of walk through, in a general way, this process, starting with notice requirements. Then we'll talk about the public hearing and what a member of the public can do at the public hearing, what you can't do, how the order of those proceedings will go, to just sort of familiarize us with that process. So Elliott, can you, there we go, great. So virtually all applications for development in a municipality are going to require public notice and a public hearing. There are exceptions, conventional site plans, unless a public hearing is specifically required by an ordinance, minor subdivisions, and final approvals, which final approvals, may sound like it may sound surprising that doesn't in and of itself require a public hearing, but the preliminary approval is really where the project gets introduced to the public and to the board. The board will come back with conditions, modifications, and then you'll have an opportunity for notice and public hearing at the preliminary approval stage. Final approval is essentially where the developer will come back with revised plans, and the planning board will look to make sure that those line up with what was required at the preliminary stage. Public notice will be given 10 days before the public hearing. That requires newspaper publication and also specific individual notice to those who own property within 200 feet of the site. Failure to give public notice will void the board's decision. So, this can come into play, when we get to the stage of litigation. If the project is approved, your attorney should be looking at, whether as sort of a first step, where the public notice requirements met by the applicant or the board. This also comes into play with zoning ordinance changes that are adopted by the governing body. If there are dramatic changes, that requires a heightened notice requirement under the municipal land use law. It can be very costly. It can be very costly for municipalities to comply with that, because they have to, send mail out, certified mail in some instances, to everybody within certain distance of zoning boundary changes, and that that can trip up zoning changes as well. So it's important to look at the public notice aspect of this. Different development applications, the boards has different timelines for each type of development application. Those range from 45 days for subdivisions, smaller subdivisions, 95 days for larger subdivisions. Minor site plans are also 45 days. Larger site plans can be 95 days. Conditional use, which for those who aren't familiar, a conditional use is essentially a permitted use, a project that's specifically allowed in the zone, provided that the proposed development complies with specific standards that are set forth in the zoning ordinance. So, for example, if it's an industrial project, perhaps the zoning ordinance will require certain buffers to be put around the actual operations, or screening in the form of a fence to sort of mitigate the adverse impact on the surrounding community from that use. Now, variances are sort of where the land use board has the most discretion, and the flip side of that is that the public really has an opportunity to make a case about why the project. Members of the public have more of an opportunity when they're opposing variances to make a case that the project's not in the public interest. And so I'm going to sort of, from here, talk about public hearings and through the lens of a variance process. Now, the time for board decisions are very important, because under the municipal land use law, if the board does not render a decision on an application for development within those timeframes, the legislature has decided that the project is automatically approved. It can be a controversial project. There can be a lot of back and forth between the board and the applicant and members of the public. But if that deadline gets blown, the project's automatically approved. So that's another important aspect of this process to keep in mind. So I'd like to just talk a little bit more about variances, what they are. In general, the two different types, which Elliott mentioned, there's a C variance and a D variance. But a variance generally allows for a departure from zoning. Your elected officials, your governing body in your town, are responsible for deciding what types of development are going to be allowed in each type of zone. That's a legislative process. And a variance allows a developer to sort of thwart that process, to go against what the legislature, the elected officials in the town have decided is appropriate, provided that the zoning board of adjustment finds that it's warranted. And again, there's an opportunity for the public to get involved there. But in every case, in every variance case, the applicant has to demonstrate what's referred to as the positive criteria and the negative criteria. And I'll talk a little bit more about each of those. C variance is essentially granted, and there's two different types of C variances, which I won't get into in detail, but essentially a C variance gives the developer relief from the zoning requirements because of an undue hardship. And that's really has to be tied to unique conditions at the site, either the physical conditions at the site, topographical conditions at the site, a weird lot shape, something like that. D variances, D variances are almost synonymous with use variances. That's sort of the most dramatic type of D variance, where the legislature has decided through the zoning ordinance that certain uses aren't going to be allowed, and a D variance allows a developer to override that. There's about 7, I believe, different types of D variances. Certain height increases over 10 feet or 10% of the allowable height also trigger a D variance requirement. So those are the two types of variances: bulk variances and D variances, which are sometimes referred to as use variances. Next slide, please, Elliott. Okay, again, a variance applicant is going to have to demonstrate both the positive and the negative criteria. To meet the positive criteria, the applicant has to show, this is generally, that the variance would serve a specific zoning purpose of the municipal land use law, and that the benefits of the variance would outweigh the detriments. And when we're talking about the specific zoning purpose of the municipal land use law, these are things that you'll find in Section 2 of the statute. They're laid out, and they're drafted in a way that has, the public interest in mind. And those purposes include, protecting from flood, protecting natural resources and things like that. So it's important to keep that in mind, that when we talk about the positive criteria and the zoning purposes, those are specific things, and they're not all drafted in terms of benefiting the private interest of a developer. Now, inherently beneficial uses are types of projects that will presumptively satisfy the positive criteria. When a developer proposes one of these types of projects, they will not have to meet the same standard that they normally would in demonstrating the positive criteria. The burden then shifts on to any objectors to sort of talk about why this type of project is not appropriate at this site, and why the detriments outweigh the benefits. But these inherently beneficial uses include affordable housing, and that's importantly not just any inclusionary development. 20% set aside is sort of the general benchmark for inclusionary development. It's not in all cases. Builders' remedies are granted with less, but 20% has been sort of a benchmark in the COA process, and the courts have said that that is not enough to qualify as an inherently beneficial use. Wind and solar power structures qualify, as do hospitals, schools. These are inherently beneficial uses that are set forth in the statute itself. There are a couple others that have been recognized, although they're not in the statute. They're somewhat controversial. Those are cell towers that have an FCC license and houses of worship. So these projects, obviously can be controversial, and whether or not they'll qualify as an inherently beneficial use, the board may have different views about that, and ultimately a court may as well. These two particular ones. Now, the negative criteria is really where the public has an opportunity to have their voice heard about why this is essentially a bad project. Why is it not consistent? Why should it not be allowed in this particular zone? Why is it not in the public interest? The burden of demonstrating this falls on the applicant. And again, that's because the applicant is coming into the land use board to try to make a case about why the zoning shouldn't apply, why this project is a better idea for this particular property than is reflected in the zoning ordinance. So there will be a public hearing on variances and virtually all of the other types of development. And the municipal land use law gives interested parties a right to participate in public hearings. You know, that's a term that's defined in the statute itself, but it's also construed very broadly. So the right of the public to be heard at the hearing is broad, and standing, which is legal word for your right to participate, is generally granted pretty liberally. And from a land use board attorney's perspective, they're going to be trying to protect the process. They don't want to get tripped up on a procedural snafu. So denying a party standing to participate, who otherwise, might or may be able to demonstrate to a court down the road that they should have been allowed to participate, can totally derail the process. So this is another area where the whole process can be tripped up. So a smart board attorney is going to, allow an interested party, a member of the public, to participate in the hearing if they're really, doing their diligence to protect the process. The quintessential interested party under the statute is a potentially impacted property owner, somebody, a neighbor, somebody who lives nearby. Although under the statute, it doesn't even have to be somebody in the municipality. It can be somebody who's concerned about, impacts on property outside of the municipality as well. Citizens, taxpayers who are interested in preserving the zone plan, in other words, who want to make a case that, let's say in an agricultural district, that we shouldn't be allowing, certain types of development that are going to have an impact on prime soils. And if that's reflected in the zoning ordinance, a citizen can come out and make the case about why, the project shouldn't be allowed to go forward contrary to that plan. Objectors asserting the community and public interest have standing, as do, in some cases, courts have actually allowed objectors with standing to be funded by a party that might not, although that has to be something that's disclosed, and everyone should be cautioned that might give the objection less weight in the eyes of the board or a reviewing court. Again, the board's decision will be voided if an interested party is not given an adequate opportunity to address the full range of issues. And objectors really should get out and participate in order to develop a record on appeal, because if the project's challenged, you're going to be stuck with the issues that are raised, with some exceptions, but the general rule is that you are limited to what was in front of the board. One of those exceptions is conflict of interest, which I'll talk about in a minute or two. Next slide, please. Great. So objectors have the right, but are not required to be represented by their own attorney at a public hearing. You can appear individually and ask questions or make comments at the appropriate time. And sort of the order of the presentation is presided over by the board and the board attorney, and that can vary from town to town. But at bottom, you will have the right to do that. If you're represented by an attorney, then you testify by answering questions that are posed to you by your attorney. If a group of objectors jointly hires an attorney, then that's something that, again, should be disclosed to the board. The board's entitled to have a list of who's in that group, and then the group would participate in the hearing through their attorney. Each individual member of that group can still testify in response to the attorney's questions, as long as the testimony isn't duplicative. You don't want everybody in the group going up to say the same thing, because the board has discretion to limit duplicative testimony. Next slide, please. Objectors also have the right to bring in witnesses to refute the testimony by the applicant or the applicant's witnesses, and objectors can cross-examine witnesses, either through their attorney if an objector is represented, or directly if not represented. Next slide. Questioning of experts. So a large part of the evidence produced at hearings is going to be factual. It's going to be based on, members of the community and people who are familiar with the town, their personal knowledge of the site and of the area. It's also going to consist of documents like surveys, plans, reports that have been submitted to the board. But the evidence is also going to consist of expert witnesses. The applicant will, in most cases, come in with professionals who are going to testify as to why the development is appropriate at the site. And objectors can also produce expert witnesses. An expert has to be qualified based on their education or professional licensing or experience. And the board can make their determination about whether the expert qualifies. Typically, the typical types of experts that you see at the land use board proceedings are professional planners, engineers, traffic consultants, architects, environmental consultants in some cases. It's really going to depend on the nature of the project and what the relief being sought is. And it's important for your expert to have their opinion be based on studies or data, not just subjective opinion. That's not going to carry any weight in the process. It'll be a net opinion, and it won't do you much good. Okay, so you're at a public hearing. What can you expect in terms of the flow of the proceedings? When's your time to speak? When's your time to go ahead and tell the board what you think about the project and present your arguments? Well, first, the applicant and his or her witnesses go first. They're sworn in by the board chair or the board attorney, and they'll make their case. And the presiding officer of the board can limit the time and the number of witnesses. They can limit irrelevant or duplicative testimony. So that, again, they have discretion in conducting the proceedings. The applicant will present their case in support of the application, and then there'll be some back and forth with the board members and the board attorney who will also be questioning the applicant and their witnesses. Other interested parties will then go and sort of go through the same process, again, with cross-examination. I see I'm sort of short on time, so I'm going to kind of quickly try to get through the rest of my slides here. Okay, again, the applicant bears the burden of proof. They have to show both the positive and the negative criteria for all variances. It's not enough as a member of the public to just submit a letter to the board. If you're opposed to a project, just writing a formal letter and submitting it is not going to do you much good, because that can't become part of the record of the board's decision. The board can put it in their file, and as a matter of good public relations, can accept it, but what your letter will not become evidence in the proceeding, and it will not, if it's ultimately challenged, it's not going to have any weight in court, unless you also appear at the hearing and testify about the contents of your letter. So sometimes you see members of the public coming out, and it's a controversial project. It's a bad project, and you will hear members of the public railing against it, which is their right and which should happen. But from a legal perspective, you really want to target your opposition to the standard that the board is going to be applying. So, for example, the negative criteria for a variance focus on how would the development impair the specific purpose or intent of the zone plan. You're going to need to look at the zoning ordinance, look at the specific district. What is the purpose of that district, and why specifically is this project run counter to that intent? And then you can get into, why is this bad for the public interest? What are the environmental impacts? How does it, does it reduce open space? Does it, whatever the case may be in the particular process for the particular project. Strict rules of evidence don't apply. This is more a caution for attorneys. It's not going to be the same as a trial in court, sort of a relaxed standard at the board proceedings. Next slide, please. Conflicts of interest can trip up the process at any point. I've seen this come up at oral argument in the appellate division, after the board proceedings, after the trial division, after the matter's been briefed. I've seen it raised an oral argument, and it completely can derail the project, notwithstanding that it's were never raised before. But there are 3 different standards for conflict of interest. One is set forth in the municipal land use law itself. There's also the local government ethics law. And courts are really going to just look at the practical feel of this situation. Does the member who participated have an interest that's different in the matter than the average person in the town? Something that would tempt them, would they have competing interests in the matter? And it's important that the standard is a potential for conflict. You don't have to actually show that the person acted on it. It's merely the potential for the conflict. That's what's required. Conflicts of interest are fact sensitive. They depend on the circumstances of each case. There's really no bright line test. But just to give you some quick examples, a doctor-patient relationship between a board member and an applicant can qualify. A board member who has a substantive leadership position in an organization that owns property near the site can also qualify. And a reviewing court might hold sort of a mini hearing to really get into the facts about whether a board member had a disqualifying conflict of interest. Open Public Meetings Act is another way that this process can get tripped up. Board meetings where action is taken need to be open to the public. They need to be properly noticed. During those meetings, the board can enter a closed session to talk about specific matters that are listed in the statute, like pending litigation, but they can't take action in closed session. They can talk about it, but they have to go back out into the public session so that the public can see government at work making their decision. Next slide, please. Okay, at the end of the public hearing, the board will vote whether to deny or approve the application, and then they have 30 days. It usually happens at the next meeting to adopt a resolution memorializing that decision. Then the legal notice of the decision is published, and that starts the 45-day clock that an objector has, or an interested party, to challenge the development in court. So this is sort of the general overlay of the process. There's a lot that I didn't cover, but hopefully that gives you a sense of the process and how the public can participate.
Thank you, Chris. All right. And I will, I'm going to be talking a little bit about a case study of kind of everything that Elliott and Chris have talked about. I'm going to go through it fairly quickly because there are a lot of very good questions in the chat right now. And I want to leave time for us to answer those. So let's do a little share screen. All right. Let me just double check that everyone can see that. All right, wonderful. So we're going to be talking about how to win friends and influence your elected officials. So I'm going to take you to a magical, faraway place called Chester Township, New Jersey. So there was a proposed turf field on a 45-acre parcel in Chester Township. The township thought they would, although it's in the preservation area, the township wanted an exemption. Specific exemption is Highlands exemption number 6. And they did not, the township did not feel that they required an EIS, which is an environmental impact study. It involved both the school board and the town council. It's a little bit complicated. I don't really want to get super into it right now, but it did involve multiple parties, so it was a little complicated. The township applied to the DEP, which triggered a public hearing on the subject. And it was eventually, the public hearing was extended. So again, we're getting back to what Elliott was talking about, delay, delay, delay. They found that there were concerns about open space funding. So how the property is initially purchased is very important to know because that can trigger certain provisions certain limitations on what the property can become, should become, et cetera, et cetera. I should also caveat this by saying ANJEC, I'm Alex Ambrose from ANJEC, by the way. ANJEC was not directly involved in this. I'm relaying a lot of this information through someone that we worked closely with. We did try to provide some support for them. But as you'll see, they didn't need a lot of support from us. So a really good first step, and I saw this going on in the chat, is be an informed citizen. So here is CJ Craig, who is my political hero from the West Wing. A really good start is just attending council meetings. That's where you're going to get a lot of your information. In the chat, a lot of people were saying, you know, sometimes there are proposed projects going on that you don't even know about. You're never going to know about them if you don't attend those meetings. Obviously, right now, a lot of them are virtual, but sometimes that's a little bit nicer. A nice short commute. Make yourself known to your planning board, your environmental commission, if you're not on either of those, and your town council and committee. I'm a professional lobbyist, and we always say that the first time you approach an elected official should not be when there is a problem or when you need something from them. You should already have that relationship with them before you come to them with a problem. Obviously, that's not going to be a good relationship in every case, but at least make yourself known to them. And finally, know your rights. So that presentation that Chris just gave, I put this in the chat. It is going to be available. This whole presentation is going to be available on YouTube afterwards. But just know what the Open Public Meetings Act is, know what documents you should have access to. There's a lot of just knowing your rights, and you're going to get really far with that. Keep your electeds informed about what you're doing. So on the right here, this is a very exciting screen capture of a Zoom meeting with the Chester Township Council. And the person who is presenting is actually a judge, Judge Hanbury, I believe is his name. He is the chair of the Environmental Commission. So yes, Chester was a little bit lucky that they had a judge as their Environmental Commission chair. But if you can give your elected officials heads up when you can, excuse me. So the Environmental Commission opposed this new project for several reasons. One of the big ones being that the Township Council just wasn't being very transparent about this application. It was a proposed turf field with lights, but initially it was just supposed to be a regular grass field. There was a lot of murky, behind the scenes muddiness going on. So give them a heads up. The judge wrote a letter to the town council before this presentation, just to let them know how the Environmental Commission felt, just a little bit of a courtesy. Then if that doesn't work, make a public presentation with a straightforward ask. So what the Environmental Commission, their strategy, again, in trying to delay this project, was asking the town council to perform an environmental impact study on the property. That was, while that was not what the end goal was, it was a good strategy in order to get them to delay this project further, or at least assess it. Form a coalition group. So as we all know, every coalition group needs a good acronym. Excuse me. So the CCCT, which is the Concerned Citizens of Chester Township, that was their coalition. I'll talk a little bit more about how they formed that identity. And if possible, fundraise and secure an attorney. So a whole bunch of residents in Chester Township got together and secured their own attorney. I know there were a couple questions about that in the chat, and I'll let Chris answer those. But these are some strategies that you can do. Forming that coalition group and getting together is very important. Next, reach out to your resources. So on the right here, we have two wonderful organizations, if I do say so myself. On the top, we have the New Jersey Highlands Coalition, and on the bottom, we have ANJEC. So find out who your local action groups are. Obviously, in the Highlands, most of you would probably reach out to the Highlands Coalition. How I found out about this entire project was through the Highlands Coalition's Policy Committee. So the Concerned Citizens of Chester Township actually became a member of the New Jersey Highlands Coalition. ANJEC is also a member of that. And they got a very good audience of very important people in New Jersey, especially in the New Jersey Highlands. Very important, very knowledgeable people. And just by attending those meetings and talking about it, they got wonderful advice. They also reached out, like I said, to ANJEC, the Highlands Council, although the Highlands Council couldn't get very involved in it. Just giving them a heads up about it and talking it through with them is a great idea. And Princeton Hydro, who I know is also here and apparently has a great booth that we should all stop by. Because the New Jersey DEP was actually the final deciding body for this, whether the town was going to get an exemption for this or not, the CCCT actually reached out to DEP as well. If you do not have contacts at DEP, again, reaching out to those local action groups who may have those contacts is very helpful. So they were actually able to talk to the DEP about what this exemption meant, what's the likelihood, et cetera, et cetera. Make your voice heard. So this is one of the most important things. The Concerned Citizens of Chester Township actually made a website. It's just citizensofchesternj.org. I suggest everyone checks this out. It's a really great website. Not only a website, but they also had a social media presence. So they had a Facebook page, Twitter. Any of these is a really good way to keep residents in touch. And it depends on who your audience is, depends on which social media platform is going to be best for you. Facebook is usually good for community groups with slightly older people. Twitter's a little bit younger, and then we can get into things like TikTok if you like, but I think even I'm a little too old to talk about that. But starting to get that momentum by gathering all those people together into a group is really important. Calling reporters, writing op-eds and letters to the editor. On their website, they actually have a list of all of their media hits, which is very important. Just not only keeping track of those, but also keeping track of them and reaching out to those actual reporters. Sending individual letters and emails, both to the local and state bodies. So like I said, the DEP was actually the final decision for the exemption, but sending letters to both the local board, the planning board, zoning board, if that's what it is, the township council, the DEP, make sure they're individual letters, so everyone should personalize their own letter. How the NJDEP works is if they receive 100 letters that are exactly the same, but with different names on the bottom, they count it as one letter. So make sure everything is personalized. And the DEP ended up denying the township for their exemption. So like I said, this wasn't necessarily what the Concerned Citizens of Chester Township wanted. It wasn't really what their strategy was, but it was their end goal. So they really were just asking for an environmental impact study in order to help delay that. The DEP denied the township, which is wonderful for that exemption. Because they were in the preservation area, they needed to apply for that exemption. And I really give this citizen action group a lot of credit for what they did. If you guys do have more questions about what they did, I'm happy to put you in touch with someone from that coalition group. Like I said, I take no credit for this. It was really a lot of the Highlands Coalition and the citizens group that did really well with that. Finally, remember, your electeds work for you. You should not have any fear in going to a public meeting and making your voice heard, sending an email to them, even pulling them aside if you see them in the grocery store. There is a reason they ran for office, and it's because they want to work for you. So don't be afraid to let your voice be heard. And thank you. That concludes my part of the presentation. And now I believe we are going to go into a lot of questions that we have in the chat. So I will turn it over to our moderator, Elliott.
Yes, thank you, Alex. That was great. So we do have a lot of questions. Chris, I see you've been answering some in the chat. Do you need me to moderate the questions, or do you want to? You're free to take them as you see them as well. And I think you're muted, Chris.
It wouldn't be a virtual meeting without somebody being muted. Yeah, I know we were running short on time, so I was trying to answer questions as best I could in the chat. But if anybody has a question that hasn't been answered, maybe they can either say it now in the chat or repeat it. And Elliott, if you want to.
Yeah, well, I can give you one that's a very specific one.
Okay.
Today in 2020, does newspaper publication still require a print notification? Is online notification on a public website or town website sufficient?
That's an interesting question. I think that newspaper publication is still required. I think that's certainly the practice. I think you know, I would definitely have to check the statute, but that's my understanding, is that it's still required. As easy as it would be to post these things online and perhaps reach a larger audience, that's still the case.
And I believe that usually at reorg, every either committee or council designates what their news outlet is, and it is, I know in most towns now, it is usually at least one print and one online source.
Are there any laws requiring a certain balance on a planning or zoning board? In other words, are there best practices that prevent politically driven selections that result in narrow or short-sighted decisions, or not in the best interest of the municipality?
No. These are appointments, and you know, there is nothing to guard against, you know, bad planning board members from serving, other than conflict of interest laws.
Yeah,
that's the short answer.
Yeah, and I think someone had also asked about training for planning board and zoning board members. So you folks can correct me if I'm wrong, but I believe planning board members have to go through a training when they initially start, and it is not a very good training from what I hear. Zoning board, I don't know if they actually have to go through any standard training. Do you know, Chris?
I'm not sure about the zoning board, but I do know that the planning board goes through the training. So, yeah, you know, the people who end up serving should be versed in the basics, but you know, that's not going to guard against you know, political bias.
Mm-hmm.
And I've known a planning board member 2 years after being on the planning board still had not taken that training.
Yeah.
People have some questions about beneficial use. Is there a standard, since not all are written in legislation? Is there a standard that proves that something is beneficial use, or is it subjective?
It's going to be based on court cases. So, you know, for example, the cell tower case that comes out of the common law, which is, you know, decisions of the boards were challenged. You know, decisions that dealt with the cell towers were challenged. They went up to the courts, and the courts made a decision. So while it's not in the statute itself, these things can be treated as inherently beneficial uses, and an applicant's attorney may, you know, raise these court cases with the board. You could see that in a letter, you know, from the board, from the applicant's attorney to the board in advance, to try to sort of, you know, pave the way for having the board treat it as an inherently beneficial use. The others, you know, that are in the statute is obviously a clear case. It's a presumption that it satisfies the positive criteria, and the applicant's still going to have to satisfy the negative criteria. It doesn't mean that it should be rubber stamped and go through. There's still things that the applicant is going to have to show to get the project approved.
Right. Okay. And could you clarify, Chris, what defines having standing means in relation to an objector? What's someone who doesn't have standing?
Well, I mean, I think it's sort of like a spectrum, right? I mean, the statute itself has a definition, and it talks about, I mean, the words of the statute are really grounded in property ownership, right? So somebody who and then within that sort of subclass, proximity to the development site is going to make the case clearer. Somebody who lives within 200 feet of the site, no question, has standing. Somebody else in the town, as a property owner is concerned about, the off-site impacts of the development, also has standing. And again, standing should be liberally granted. There are court cases that talk about people in the community having the right to come out and object if they don't want to see, the zone plan thwarted. So, you're sort of getting to the other end of the spectrum where you may get some resistance from the board attorney. But again, my advice, based on my experience, in this area, is that a board attorney would be wise to allow an objector to appear fully in the hearing, because an objector that has the resources to fight it all the way up to the courts could derail the whole process if they're not allowed to participate in the court finds that they should have been allowed to.
Right. But for example, I'm an employee of the New Jersey Highlands Coalition. We're located in Boonton, but in a town in western Warren County, very far from where we live. But I'm still concerned about the natural resources of the entire Highlands region. However, the board attorney may not want to hear from me because really they want the development, and I'm going to be someone they want to exclude. But I say I have standing.
Right.
This is a concern of mine.
Yeah, there could be a fight. Could be a fight about that, for sure.
Okay.
In my mind, you can make a great case for the Highlands Coalition being able to do that. They're vindicating the public interest under a state statute in the preservation of natural resources. So I would love to have that. I'd love to have that.
Well, we may be talking to you about that down the line.
Elliott, someone has a very good question that I think you and I can answer. What are effective methods to approach reporters about writing an op-ed? Should I write it and send, or ask first? So I have an opinion about this, and then I'd love to hear what Elliott says. So the more local the outlet, the more likely it is that the op-ed will be published. So always start local. Start at like your Patch or any other local paper that you have. It is totally acceptable to write it and then send it to a reporter. Although it is always nice to give them a heads up and just say, hey, this is something that I believe is going to be coming up. It's going to be very important to the public. And then you can give them a time frame for when you'd like it published. Reporters don't mind that at all. Once it's published in a more local paper, it's more likely that you can take the next step up and maybe do a regional, like northjersey.com, and then you can work your way up to like nj.com, which is like the standard for everyone, Star Ledger. And it's totally, your relationship with a reporter should be pretty similar to what it is with an elected official. It's totally fine to approach a reporter and just say, hey, these are some things that I care about. Develop that relationship first before you pitch to them.
Yeah, one thing I would add, if you're going to invest the time in writing a good op-ed, it is important to find out who the editorial page editor is, and let them know, ask them if they would like one, try to sell them on it, and they may invite you to do so, to write it, to submit it, which is, you don't want to spend a whole day writing one and find out they're really not interested. But we're out of time. It's 10:10. Thank you, everybody, for joining us. This is a very interesting topic. It's something the three of us here are very involved in, and we're in some way involved in fighting bad projects, and that's what we do, and we'd like to hear from you when there are projects you're concerned about.
Yeah, I put my email in the chat, and there's also obviously the direct message function. I encourage you to reach out to myself or anyone on this panel. We are here to help. And I saw a lot of people saying that this should have been a day-long session. I think it's safe to say, Elliott and Chris, perhaps we want to do this again as another webinar.
That'd be great.
Yeah. So keep an eye out for that. Sign up for our email alerts, and we'll let you know next time we do this.
Thanks, Elliott, and thanks, Alex, and thanks everybody for the great questions and being so engaged.
Thank you, Chris. Thank you, Elliott.
Thanks, guys. And I think it's time to go back to the main stage.
See you all there.
See you all there.
Bye-bye.